Well, good morning. It's the 15th of May. It's 10 o'clock. I'm Gavin Wyman. This is another episode of Sorry. Let's try that again. Good morning. It's 15 May. It's Friday. Contractually Speaking, it's the next episode of FIDIC Fridays. We ended up last week having a look at pricing and price risk and the manner in which this is dealt with by FIDIC. What I'd like to speak about this in this slot, remember the slot is Fridays from 10 to 10:45, and I am thinking of introducing slots on Thursday, 2 slots and another slot after this on Friday for the other contracts, JBCC, GCC and the NEC. But what I plan on addressing today is, from a South African perspective, the regulatory relevance of the FIDIC contracts. I did address this last week, I think, and as well as some aspects of the commercial relevance, but I need to revise the regulatory relevance portion of that. So this is what I'm going to do this morning. Now, I may have mentioned to you last week that in South Africa, the Construction Industries Development Board has a gazette that they publish, and in the gazette they list the various contracts available for use by the state, as it were. In fact, not as it were, the state, when they contract within the built environment industries. The gazette that was current was one from July 2015, and I wrongly stated that that was the latest gazette. I have since found that there is an updated gazette dated August 2019. The reason I did not find the updated gazette when I searched for Google was that I typed in my search engine the words Standardisation Gazette, which was the label under which all the previous gazettes were found. They had not used the word standardization. They used the initial SFU, standard for uniformity, in their search, in their labels, and therefore I did not pick it up until I actually examined the CIDB website more closely. So the new Standardisation Gazette is dated August 2019. This means that all contracts entered into after the August 2019, if a government is the employer of the contractor or the client of the contractor, they must use one of the forms of contract listed in the normative reference, which is item 2 in the table of contents, the standard contracts prescribed by the regulator, in this case the Construction Industries Development Board. Now, one of the reasons I also want to address this is because of the changes brought about by this gazette, which of course is now relevant for all contracting between parties where one party is the state after August 2019. And remember that the state includes all entities listed in any of the annexures to the Public Finance Management Act or the Municipal Finance Management Act, as well as all constitutional entities and of course organs of state themselves, departments, directorships, sorry, I'm making a hash of this, government departments, etc. So what has changed? Well, this is quite important. You will see that I have highlighted in gray this box over here. This hasn't changed, but this is an important indicator or important rule for reading the list. The grayed out box says that for undated references, the latest edition of the reference document, including any amendments, applies. Now, in the previous Gazette, the FIDIC contracts were dated references. So, for example, when they referred to the Red Book, they said the conditions of contract for construction for building and engineering works, the Red Book, first edition 1999, as published by the International Federation of Consulting Engineers. So the reference to a date or an edition has been removed. So to now read the clauses relating to the FIDIC Red, Yellow, Silver, etc. books, you are using the latest edition together with any amendments of the Red Book. This means that the latest edition of the Red Book, which is the second edition, 2017, applies, as for the Yellow and the Silver and the Gold books. The Green Book is also listed on the next page, where sort of as an afterthought. They haven't bothered changing that afterthought and bringing the FIDIC contracts all together sequentially. So all that they've done is they've brought up the Word document, I suppose, and edited it and then republished it. So it's important to understand that a FIDIC second edition is now the prescribed edition for use in South Africa and no longer the first edition. I'm not so sure that that's such a great idea. I think there are some problems with the second edition, and these will plague or at least complicate projects done under those new edition contracts. While I'm on the topic, I may as well also just address the other issues. The other issues are the JBCC contract. You will see and the GCC contract. You will see that item 2.5 is the GCC. The GCC contract, or the General Conditions of Contract for Civil Engineering Works, is the contract by the South African Institution of Civil Engineers, SAICI as we call it, whose offices are in Thornhill Park in Midrand. Their contract, their latest contract, is the third edition, 2015, and that edition was the edition in the previous Gazette as well. It hasn't altered, in other words, and they've simply removed the reference, the dating of the edition. So the latest edition applies, which is still the third edition, 2015. The slide is wrong when it says 2025. The 2 is a typo. I'll fix that. And the JBCC contracts, the JBCC contract, or the Joint Building Contracts Committee's contract, they have a principal building agreement and they have a minor works agreement. They also have a nominated selected subcontract agreement that you are forced to use because the terms of the prescribed contract refer to that edition of the subcontract, so it's included by reference. The principal building agreement 6.1 was the edition prescribed in the previous Gazette, that dated reference has now also been removed, so the latest edition of the principal building agreement then is currently version 6.2. So these will be the editions of the JBCC and the GCC that we will address when we do talks under Contractually Speaking for GCC and JBCC contracts. The biggest problem that they've caused, so far there's nothing peculiar about this CIDB issue, but I always get the impression that the CIDB don't quite know what they're doing or quite understand things precisely. So the NEC reference is where the problem is. Previously, in the Gazette of July 2015, they listed most of the NEC 3 contracts. So remember, NEC is a brand name. It's an edition number, if you like, NEC 3, and within that they have a family of contracts, also represented by acronyms, I suppose red book, yellow book type acronyms within FIDIC. The NEC contracts would be the ECC, Engineering and Construction Contract 3, the Engineering and Construction Subcontract ECSC 3. Then there would be a short contract, the NEC Engineering and Construction Short Contract, Engineering ECSC. And there was a subcontract to that. Then NEC also had a SC, a Supply Contract 3, as well as a Term Service Contract, TSC, and a Term Service Short Contract, TSSC. Sorry, it's a little bit of a tongue twister to sort of rattle them off this way. And all of these contracts were prescribed in the previous edition of the Standardisation Gazette. And Eskom, for example, who is a large user of NEC contracts, in fact, it's their go-to contract, typically are big users of the NEC 3 TSC, Term Service Contract 3, and the Term Service Short Contract 3. They use it for 90% of their maintenance. And they normally use the Engineering Construction Contract 3 for larger projects that are one-off, that are not something you want to have on hand to do as and when required over a 3-year period. And that was fine. A very good use and a best practice to use a term service contract along those lines. FIDIC have no equivalent, nor do JBCC or the GCC for that matter have a contract that is that usable and that valuable. Now, what the CIDB have gone and done is they have listed NEC. Now, NEC 3 was never a dated reference in any of the earlier Standardisation Gazettes. In fact, they were previously the only undated reference, which meant you must use the latest edition of the NEC 3. Now, NEC 3's first edition was 2005. They then brought out an edition in 2007, and then they brought out an edition in 2011. So these are different editions of the NEC 3. In 2016, NEC brought out NEC 4, which is an evolutionary change to the NEC 3 family. But the family is now called the NEC 4 family. NEC 4 is not a new edition of NEC 3. It is a brand new edition. NEC 4 is not listed at all in the CIDB Gazette. The changes to the from NEC 3 to NEC 4 are less drastic and much better than the changes brought about, for example, between the FIDIC first edition and the FIDIC second edition. It's clear that this was not understood by the framers of this regulation. That is the first problem. It should have included the NEC 4 contracts and not the older NEC 3 contracts in the Gazette standard upgrade. Clearly an oversight or error or arising from a lack of insight into contracts, the actual families of contracts involved here by whoever did the edits to this Gazette before it was published. But it goes, it's worse. It's much worse, in fact. They only list 2 of the NEC contracts, NEC 3 contracts. They only list the Engineering and Construction Short Contract and the Engineering and Construction Contract. No Term Service Contract, no Supply Contract, and no Term Service Short or Professional Service Contract. Now, that's all fine and well. But previously, in the previous Gazette, the CIDB published their own contracts as well. Particularly, they published their own procurement contract, purchase in goods and sales, which is a contract which you would then use when acquiring free issue if you were going to supply it as the employer, and you would use that. And they also include their own version of a professional services contract if you wanted to engage the services of the engineer or of the principal agent or employer's agent, the person who's administering the contract on behalf of the employer. Previously, you could use the NEC professional services contract to engage the services of a consultant along these lines, or you could use the CIDB's own services contract. They have omitted both of their own contracts from this new Gazette. Accordingly, in this new Gazette, there is absolutely no contract whatsoever that one can use for the procurement of goods or for the hiring of professional services to administer the engineering contracts that you are using under this. This is a major problem, because without these prescribed contracts, procurement of goods, services of a professional nature would now have to be done, I suppose, under the Treasury General Conditions of Contract, not to be confused with the Conditions of Contract for Civil Engineering Works produced by SAICI. This is a document that Treasury regulations require to be included in every contract of theirs, unless, of course, it's regulated by the CIDB. It is now no longer. The Treasury General Conditions of Contract is a relatively poor set of general conditions, mainly skewed around goods and incidental type goods, but completely inappropriate for hiring a consulting services. The fate of the what was that entity called? There is a PROXA professional services contract created in South Africa by a coalition of professional service providers along the lines of the JBCC. That contract, I think, is now in edition number 3, and they've been trying to get this professional service contract included in the Standardisation Gazette, well, since forever, and it has been refused to them. And the reason apparently given, again, this is hearsay, is that it does not comply with Treasury regulations. Supposedly, the contracts that for professional services that did comply with Treasury regulations would thus have been the NEC 3 professional services contract, PSC 3, and the own contract provided by, in this case, the CIDB themselves. So it's kind of left this whole thing in limbo. A further interesting aspect of the Standardisation Gazette, and this is probably not a bad thing, is the gazetting of the standard. So previously, the annexes to the CIDB Standardisation Gazette referenced the SANS 294 South African Standard for Public Procurement Processes. Now in the normative reference, they include the upgrade, the SANS 10845 1234, which now includes the new tender document, an updated tender document. It creates an updated form of offer and acceptance, and contract tender data, and so on, which is a much preferable sort of procurement standard than the SANS standard that they were using earlier on. The important upgrade is the fact that the new standard does not make things like the form of offer and acceptance normative, and the data document normative, and so forth. It makes them illustrative of how it ought to be done, which is fairly useful considering that the form of offer and acceptance could be tantamount to a form of offer and counter offer, and the tender document itself does not require you to use the form of offer and acceptance other than as a deviations document and an interim document before you actually sign a formal contract agreement as prescribed in the text of the Annexure F, the standard tender document. Again, it is my view that the CIDB has never properly understood that little nicety within their standard tender document, that you cannot accept subject to conditions and amendments and changes. That's a counter offer. The moment you are doing this, it is incumbent upon you to sign a formal contract agreement as NEC, as FIDIC do, and this is done around the world. You cannot use the form of offer and acceptance where there are deviations to form the contract. You can use it as a component of the contract. And that is quite an important topic. In fact, this should be addressed in a whole session relating to the actual formation of contracts. But I plan then to move on. So, sorry, let me just take a moment to have some coffee before it turns entirely cold. Okay, so I seem to have a concurrent viewer. I'm not sure who he is. If you are watching and live, you're very welcome to say hello in the chat. I should be able to pick it up on the side here, but not. One concurrent view might well be me. I'm not sure how this particularly works. I don't announce these things live. I'm hoping people will find me by osmosis. But I'm going to edit these versions, and I'm going to, I suppose, let everybody in the construction world know, and everybody on Facebook know, of this particular series of talks. Obviously, when we get to the end, we will probably revisit and start again and discuss new things, but then hopefully we will have people engaging in the process with me who might liven up this process, expand my consciousness with their erudite questions, and make the thing a lot more interesting for all concerned. While I'm on this and advertising what I might be doing and what I'd like to do in the future, I'm busy planning a series of online training courses that are still in development. There will be one for contract law, one for engineers, of course, and consultants and contractors, one for FIDIC, NEC, JBC, and GCC. Later, we might produce extensions of these, or beginners versions, intermediate versions, and expert versions of them. But we will just now produce the mid-range, normal, expected expert knowledge required of people in the industry in the 4 contracts. The courses will be done on a online learning platform, so you'll be able to do a lot of the learning on a self-paced course. You'll be able to ask questions to your facilitator via the inbuilt email system and get replies to it. We will, if we have groups, be able to have discussion groups, forums, to discuss aspects of the contract. So if you're a company and you want to put a cohort together, 5 or 6 people to go through the course together, we could then structure that more fixed in time with diaries and things, so that we can complete it over, say, 3-4 weeks. And the idea is that these will be registered for CBD points as well. There's a lot we can do with this. It's quite exciting. We can create a kind of wiki resource as well, relating to the contracts that various students can delegate to as they do research for the thing. Now, for CBD points on an online learning platform like that, you basically don't need to be assessed. When I do 2-day or 3-day face-to-face courses on FIDIC or NEC or any one of the other contracts, we don't assess the delegates. They sign an attendance register, they get a certificate of attendance, which is sufficient for the engineering council's CIDB purposes to give them normally 2 CBD points, 1 per day, for attending a course and discussing contracts in this way, their immersion. They've got a certificate of attendance, not a certificate of competence. So the online learning platform will issue a certificate, and once it's been registered with AXA, the Engineering Council, that certificate will entitle your CBD points. Remember, this is still in development at this stage. If you're interested in participating as a guinea pig and offering some sort of comments and critique on the actual courseware to help get it into shape, you won't get CBD points, but you will be able to engage in learning about contracts if that is of interest to you, other than just acquiring the points to tick your boxes for your business world. The thing I was thinking of doing was actually providing an assessed version as well for a small additional fee, where I would do assessments, and the website myself as the facilitator would give you a certificate of competence. Now, this certificate's not from a university, it's from a private institution, but Wyman is a well-known name in the training world of the construction contracts, and if you get a certificate from me that you've passed assessments that have a higher level of competence than a mere attendance, and that is valuable to your employers, or to you for your CV purposes, I'm not going to charge an extra fortune for doing the certifications. It will just be a nominal additional fee for a more hands-on version of a canned course, I suppose, a self-directed online course. Self-directed online course that is self-paced with minimal involvement by tutors is fairly similar to doing a UNISA course or any other open university course, where you have assessment at the end, and where you don't have assessment at the end, you'll merely tick the boxes and do a few multiple choice questions just to make sure that you've understood the very basic elements and didn't just click through the slides, click, 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 click to get to the certificate at the end, and therefore you actually didn't pay any attention whatsoever. I think the perverse minimum of that should be a requirement for the CPD points. But the questions won't be challenging, they will just be to show attention throughout the process from the CIDB process. But for the certification, you'll be required to show that you've understood and have some sort of insight into this. And then I'm also willing to engage in webinars or some other form of e-meeting with delegates to help them cement and conceptualize the ideas learnt in the self-paced course, so that the creative and more constructive thinking processes can then also be built into you, so you come out of this actually an expert in the understanding of the contract and its application. Anyway, that's enough of a blurb relating to that. Let's move on. I think I did last week speak about the commercial relevance of contracts, and I think I spoke about the causes of contract failure and the critical importance of contract administration in and making sure you read and understand the contract provisions. So we begin then with the second half of this hour by having a look at the law of contract. And the issue here is, why does it matter? That's the first question, I suppose, to be answered. And the only reason it matters is because a contract like FIDIC or any of the other engineering standard forms do not stand in a vacuum. They stand within a broader framework of law that creates rules that make agreements, for example, when certain elements are met, binding legally on the parties. Now, it sounds like such a simple question to ask, what does it mean when one says that a contract is legally binding on a person? What is a legal bond? And the answer to that question is actually quite frightening. A legal bond is a bond welded in violence. Now that sounds very, very dramatic, but it is true. A legal bond is a bond that, if it is broken, allows punishment, coercive force to punish in some way the person who has broken the bond. So the bond that we are talking about in the law of contract is a bond created by consensus, by consent, or agreement, depending on which words sound better for you. There is a level of truth in all of the three words. Once you and another party have a meeting of minds, undertake obligations, grant each other rights, the British lawyers call it reciprocal promise making. Once you've made a promise, and that promise is legally binding, if you break that promise, the law punishes you, at least in theory. It's not that it has to punish you, but that the remedy of the person who's been harmed to seek that punishment is always underlying what a contract is. An agreement? No. An agreement by itself is not legally enforceable. Unenforceable agreements or unenforceable contracts are sometimes called naturally occurring agreements, as opposed to ones that have become unnatural because man's legal rules have embedded themselves into that agreement and made them very specific. Now, the law of contract is actually quite imposing. One could almost go so far as to say, well, it has been said by writers in the Roman Dutch tradition, Nathan, for example, that we are bound by seriously meant agreements. What this really means is that there are certain elements in addition to agreement, the serious part of it, necessary to make an agreement a legal bond as opposed to being a non-legal bond. But typical examples of non-legal agreements would be social arrangements and promises. If I make an offer to buy coffee for a colleague at work and they accept my offer and they don't meet at the agreed time, they stand me up, as one might say, well, I can't sue for breach of contract because the law does not assume a legal bond arises there, because the law assumes that the intention of the parties is not to be legally bound. So intention is a critical element making a agreement binding as a legal bond. But anyway, so that is this framework of laws, how they work. What is an offer? What is an acceptance? What is intention? What is legality? What is possibility? What are formalities? These are all provided rules of contract law, general principles of contract law, as it were, that decide how and when a contract becomes binding. So this is the first fact. The second fact is that every country has got its own law. South African law doesn't apply in its neighboring states or in the United States. United States law does not apply in England. So United States has contract law and England has contract law. But one is the United States contract law or the contract law of Louisiana or California, and because it's a federation. And in England, it's not a federation. So you have the law of England and Wales and the law of Scotland and the law of different countries' law, different jurisdictions. Each one of these has their law of contract. Are they all the same? No. They are mainly the same. Why? Because they mainly have a common ancestor. And the common ancestor was Roman law. Okay, remember Roman law. Rome conquered the world. It was one of the first major empires. I know the Greeks had an empire, but none as impressive as the Roman Empire. and the Romans succeeded in maintaining the empire with mastery of governance, which is law. And they had a specific version of Roman law that applied in all their colonies or provinces. They called it the jus gentium. Jus, law, gentium, peoples, the law of peoples. And the law that applied to the citizens in Rome itself was called the jus civilis, law, the law of the citizens. So English law is basically Roman law melded with customary English norms. Scottish law, Roman law melded with Scottish norms, traditions. Dutch law, Roman law melded with the Dutch traditions. Now, South African law is Roman Dutch law. It's a common law system based on the common law of Europe, mainly the Dutch, but in that area would have included very similar law in France and in Germany and in Holland and the Netherlands. This Roman law wasn't too different. But anyway, this is why contracts then have to have clauses like the specific FIDIC clause I'm showing you now. And this is clause 1.4. It's got a heading, Law and Language. It comes from the second edition, because this is the edition I'm going to be discussing, since it's the current edition according to the CIDB's Gazette. This provision states, the contract shall be governed by the law of the country. South Africa is a country. United States is a country. Or other jurisdiction, California, New York State. These are jurisdictions stated in the contract data. If not stated, the law of the country. Country, defined that way, means the law where the works or most of the works are being done, in another definition, in the FIDIC contract, excluding any conflict of law rules. And then below that, I've shown you the contract data line, or the line in the contract data that would provide the data for that particular subclause. The subclause is clause 1.4, says the data. The data to be given is the contract shall be governed by the law of ... and the data is the Republic of South Africa. So the variable Republic of South Africa is held in the data item. So if you fill out or create the contract with that data, then when interpreting the FIDIC contract, you will use the rules of interpretation of South Africa's Roman Dutch law of contract in interpreting the contract. What does it mean when it says excluding any conflict of law rules? I think there is a slide that deals with it over there. I think I may even have done this last week and might be repeating it. I'll just double check that. So this next slide actually shows you that, law is different in different jurisdictions. You've got common law systems like in America, in South Africa, although they're not the same common law systems, they have a similar flavor to them. You've got customary law systems like in Tibet, as we had in Africa. Then you have mixed systems where customary law gets mixed with common law and you end up with grey. For example, as you see there on the east of Africa, the former British colonies have sort of mixtures of British common law and customary law, and the French colonies on the west of Africa are sort of fairly orangey. That is a mixture, I suppose, of red and yellow, for European civil law mixed with customary law, and so on. I think I also did mention the order of precedence clause, so I'm not going to repeat that. I think I have been here before in a last lecture, and I think I also showed you FIDIC's order of precedence clause. If not, when I edit that version, I'll have a look and I'll make a note to maybe discuss this a bit further later. But the conflict of law provisions referred to here if not so stated, the law of the country, excluding any conflict of law provisions, is this issue here. South Africa's international law, and in this case international private law. What this means is that, say a South African meets a Frenchman in Papua New Guinea and signs and negotiates a contract in Papua New Guinea to do work in Botswana. Which legal system will apply to that contract? Will it be the law of the one party, South African, or the other party, Australian, or the place where they concluded the contract, Papua New Guinea, or the law of the place where the work is to be done? Well, obviously the FIDIC clause says that if we agree, it will be the law of the Republic of South Africa. If we don't agree, it will be the law of the country, which would be Namibia. But if the common law applied, the conflict of law provisions applied, South African law would say the contract would be governed by the law of the place where it was concluded, which would be Papua New Guinea. Now, that sounds terribly, terribly complicated, and to avoid all this complication, make sure you fill out the data for clause 1.4, and in agreement with the your counterpart, agree which legal system you want to use as a baseline legal system of contract law for interpreting your contract's validity, for interpreting its meaning, for calculating the quantum in breach, and for termination of the contract. Most legal systems will regard your text as overriding, mostly, of any law provisions in their contract. So when you enter into a contract in writing and your contract conflicts with common law provisions of what the content of a contract might be, your content will override it. I can give you an example of that a little later, maybe. There is a slide, I'm just not sure whether it will happen this week or maybe next week. Contracts as risk management documents, I think I was approaching it that way last week, particularly when we were talking about the commercial risk elements, the Arcadis report and so on. Maybe an element of this worth addressing today in the few minutes we have left is the nature of a fiduciary and a non-fiduciary contract. It is probably quite important to understand that a works contract of the type that a construction contract is, a FIDIC, an ECC, a JBCC, PBA, these contracts are all elements of a so-called works contract. You'll see it down there on the list, this bullet here. This means that this contract is reciprocal or entire. There is no specific fiduciary duties generally built into the contract. In other words, you comply with the terms of the contract. There isn't a general duty of good faith, a fiduciary duty. Whereas there is a general duty of good faith in the contracts like employment and partnership and professional services. And what this entails, I suppose, is something that we can have a greater look at to next Friday. Maybe we can also have a look at the fiduciary nature of NEC contracts and how these are almost like quasi-consulting contracts, and also talk a little bit about the nature of a consultant's contract. So yeah, thank you for your for tuning in. Please remember to tune in next week at 10 o'clock for our next edition of Contractually Speaking, FIDIC Fridays. Also, you can have a look at my website for a publication timetable, which I'm going to put up today, and I will also make sure I put this up on my Facebook page, and I will also make sure, see if I can do some sort of announcement for a timetable of publications of these talks on my YouTube channel. But for now, have a great weekend, and I hope you enjoyed this latest edition of FIDIC Friday. Cheerio. I am finishing off a minute earlier today. Isn't that interesting?